Hello viewers, I am Dr. Daniel Matthew from National Law University, Delhi. And today we'll explore one of the most fascinating principles in property law, the transfer of property by unauthorized persons under Section 43 of the Transfer of Property Act. Now, this principle is also known as feeding the grant by estoppel. It addresses a unique situation. What happens when someone sells property that they don't own, but later acquires ownership of that same property? The answer lies in the intersection of equity, fairness, and the doctrine of estoppel, creating a complex but crucial protection for property transactions. At the end of this lecture, you should be able to 1. Understand the concept of property by unauthorized person under Section 43 of the Transfer of Property Act. 2. Identify the key components and conditions which are necessary for Section 43 to operate. 3. Analyze the role of fraudulent or erroneous representation in property transfers. 4. Evaluate the importance of consideration in unauthorized transfers. 5th, comprehend the concept of subsequent acquisition of interest and its implication. And finally, distinguish between valid and invalid transfers under Section 43. After completing this lecture, therefore, you will be able to apply the principles of Section 43 to real-world property transfer scenarios. 2. Assess the validity of property transfers made by unauthorized persons. 3. Explain the relationship between estoppel and property transfers. 4. Determine when a transferee can claim rights under Section 43. 5th, analyze the protection which is available to subsequent transferees in good faith. And finally, navigate the interplay between Section 6A and Section 43 of the Transfer of Property Act. So with this background, let's delve into this intriguing topic. Section 43 of the Transfer of Property Act deals with transfers made by unauthorized persons who subsequently acquires interest in property so transferred. It notes that where a person fraudulently or erroneously represents that he is authorized to transfer certain immovable property and professes to transfer such property for consideration, such transfer shall, at the option of the transferee, operate on any interest which the transferor may acquire in such property at a time during which the contract of transfer subsists. It further provides that nothing in the provision will impair the right of transferees in good faith for consideration without notice of the existence of said option. Therefore, we have to look at some of the key components. What are they? 1. A person fraudulently or erroneously represents that he is authorized to transfer certain immovable property. This transfer is for a consideration. Such transfer is at the option of the transferee, operate on any interest which the transferor may acquire in such property at a time during which the contract of transfer subsists. The right of transferee in good faith for consideration without notice of the existence of the said option is not impaired, is not affected by this provision. Of importance here too is the principle of estoppel, on which this section is based. Here it is also known as the feeding the grant by estoppel, as we discussed earlier. Only a person who has an interest in an immovable property can transfer that property. That's the general rule. However, a person who does not have any interest or title in a particular property can neither transfer the property nor convey any title to the transferee. Again, the general rule. The law thus provides that a person who has no authority to transfer an immovable property and professes to transfer such immovable property, then such a person is estopped from refusing to transfer when such a person subsequently acquires the authority to transfer. Thus, two clear principles that can be seen to operate here are: one, as I said before, the common law doctrine of estoppel by deed, and two, the equitable principle that a person who promises to do more than he can do must fulfill that promise when he gets the ability to do so. Thus, a scenario envisaged under the provision is where a person who, though having no title, represents that he has present and transferable interest in an immovable property, and based on this representation, the transferee for consideration takes the transfer. On the satisfaction of the above noted conditions, the transferor later acquires the property, then the transferee becomes entitled to this immovable property, provided that the transfer is still persisting and has not been cancelled. Let us take an example to better understand this position. Vinod, who has separated from his father Prakash, sells to Suman three fields X, Y, Z, representing that he is authorized to transfer the same. Of these fields, Z does not belong to Vinod, it having been retained by Prakash on partition. But on Prakash's dying, Vinod, as an heir, obtains Z. Suman, not having reinstated the contract of sale, may require now Vinod to deliver Z to him. Here, Vinod, on partition, got three properties X, Y, Z, which he sold to Suman. But at the time of sale, he was not authorized to sell Z because that was retained by his father Prakash on partition. On the death of Prakash, the property came to Vinod. And as I said earlier, if at that time Suman had not cancelled the contract of sale, then in such cases the property would go to Suman as per the original sale. Now, for the application of this section, therefore, the following conditions must be satisfied. 1. Competency. The person making the contract for transfer was competent to contract. 2. Contract was subsisting at the time when the claim for recovery of property was made. Now, in Durga Prasad Shrestha versus Special Secretary Tourism Department, Government of Sikkim, the Sikkim High Court in 2018 observed that the provision of Section 43 of the Transfer of Property Act made it very clear that when a person with imperfect title transferred the property for consideration and subsequently the transferor's title became perfect in law, the transferee was entitled to enforce the terms of the contract by equitable doctrine of feeding the grant by estoppel. In other words, the property embodied in Section 43 of the Transfer of Property Act is described as the common law doctrine of feeding the grant by estoppel. The law assumes that the transferor had no title over at least a portion of the property he had transferred, but which he subsequently acquired, in which case, upon the principle of elementary equity, he is bound to make good his representation to the transferee. It is therefore clear that what is of relevance is that the transferor at the time of transfer had no title on the property, but this title he later acquires with the passage of time. In such a situation, estoppel operates, and the transferor is estopped from denying or refusing the transfer provided other conditions are fulfilled, including, as we mentioned earlier, agreement between the parties continues to subsist. So, on the basis of representation made, the person making the representation is now estopped from alleging to the contrary as against a person who has acted upon that particular representation. This is the idea of estoppel. It is therefore immaterial if the transferor acts bona fide or fraudulently in making that representation. The principle contained in this provision, however, shall have no application in some types of transfers. What are they? For instance, this section does not apply where the transfers are A. without consideration, or B. forbidden by the law on grounds of public policy, or C. was an involuntary transfer. Additionally, erroneous or fraudulent representation by the transferor must be specifically pled for Section 43 of the Transfer of Property Act to apply. Unless this is done, Section 43 has no application. Therefore, let us now look at the idea of what is fraudulent or erroneous representation. A key requirement for the application of Section 43 is that there must be fraudulent or erroneous representation. In other words, the representation made must be false, untrue, or dishonest in nature, and must be made by the transferor to the effect that he is authorized to transfer the property. In Narayan Chandra Saha versus Dipali Mukherjee, the Calcutta High Court in 2002 observed that the purpose of the application of Section 43, Transfer of Property Act, fraudulent or erroneous representation by the transferor to the transferee is must. Without this, 43 has no application. The provision, however, does not require that both the requirements be fulfilled, namely that the representation, if erroneous, should also be fraudulent, because fraud is not a necessary ingredient of the law of estoppel. However, simply making of a representation is, while necessary, not sufficient. Such representation should also have been believed and acted upon by the transferee. So, in other words, even though the representation was fraudulent or erroneous, but it was not acted upon by the transferor, then Section 43 has no application. To put it differently, if all involved parties know the truth, then the principle of estoppel will have no application. Therefore, the transferee, if they knew as a fact that the transferor did not possess the title which he had represented to them, then the transferee could not be said to have acted upon the basis of such a representation when taking a transfer. Therefore, and consequently, Section 43 of the Transfer of Property Act would have no application. As was held in the case of Juma Masjid versus K. Devaiah, a 1962 decision of the Supreme Court of India, it is immaterial whether the transferor acts bona fide or fraudulently in making the representation. It is only material to find out whether, in fact, the transferee has been misled. For the purposes of this section, therefore, it matters not whether the transferor is acting fraudulently or innocently in making that representation. What is of consequence and what is therefore material is that he did make the representation and the transferee did act upon it. Where the transferee knew as a fact that the transferor did not possess the title which he was representing that he had, then he cannot be said to have acted upon the representation at the time of taking a transfer. As a result, Section 43 would have no application. But where the transferee does act on the representation, he should have the benefit of the equitable doctrine embodied in Section 43, however fraudulent the act of the transferor might have been. Similarly, where it was shown that the transferee had made independent enquiries and only then participated in the transfer, it cannot be said that the transferee acted upon or was induced by the representation. Another key concept within Section 43 is the idea of consideration. This condition should be fulfilled. In other words, the transfer should have been made in exchange of a consideration. Section 43 therefore will have no application when the transfer comes as a gratuitous. It applies only for transfer for value and therefore can apply to transactions like mortgage, like sale, like exchange, or something like lease, as they are supported with consideration and are not gifts. Similarly, a key concept in this section is the idea of subsequent acquisition of interest. This is the third key requirement for the operation of this section, and that is that the transferor must acquire interest in the property which he has agreed to transfer. Now, on the happening of such subsequent acquisition of interest by the transferor, such interest will, on the operation of Section 43, pass on to the transferee, if the transferee still wants the interest and the agreement to transfer still exists. It is not necessary that the transferor should acquire interest in the entire property he had agreed to transfer. Even if part interest was acquired, such part interest will also pass on to the transferee, provided the two conditions noted above are fulfilled. There must be parity in the nature of interest. In other words, interest subsequently acquired must be the same as was originally agreed to be transferred, and it must be acquired in the same capacity in which the transferor agreed to transfer it. This section does not operate on any other property acquired by the transferor. As noticed earlier, for the claim of transferee to succeed, two clear conditions are required to be fulfilled. The first one concerns the transferee's action, namely that the transferee has to exercise his option after the transferor has subsequently acquired interest in the property. If the transferee does not exercise this option, then the interest will not move to the transferee. Such movement does not happen automatically. The law does not provide any specific format for exercising of option by the transferee. The desire and exercise of the option by the transferee to acquire the property is gathered from the acts and conduct of the transferee. Similarly, while immediate action by the transferee on the acquisition of interest by the transferor is not the requirement under law, it is, however, expected that the transferee will act within reasonable time of the transferor acquiring interest in the property. Delays may result other possibilities, such as the transferor further transferring the property to a third party for valuable consideration. The transferee may acquire their option at any point of time during which the agreement subsists. This section clearly does not mention how the option has to be exercised. Therefore, any action indicative of such option will be sufficient when a transferor transfers any immovable property as his own to operate on any interest in such property which he subsequently acquires. Once the option is exercised, the transfer would be treated as valid, and later suit for cancellation of sale shall not be maintainable. The Supreme Court of India, speaking on this aspect in Tanuram Bora versus Pramod Chaudhary Das in 2019, observed that if at the time of transfer the vendor transferor had a defective title or had no title or no right or interest in the property, however, subsequently the transferor acquired the right, title, interest, and the contract of the transfer subsists, in that case, at the option of the transferee, such a transfer is valid. In such a situation, the transferor cannot be permitted to challenge the transfer, or the transferor has no option to raise a dispute in making the transfer. The intention and object of Section 43 is based on the principle of estoppel as well as equity, as we mentioned before. The intention and object is that after procuring the money, that is the sale consideration, and after transferring the land, thereafter the transferor is stopped from saying that though he had sold or transferred the property or land on payment of sale consideration, still the transfer is not binding on him. That is why Section 43 of the Transfer of Property Act gives an option to the transferee and not to the transferor. The intention of Section 43 is that nobody can be permitted to take the benefit of his own wrong. Accordingly, the transfer takes place not when the interest is acquired, rather at the time when the transferee exercises their option to acquire the interest. Further, the transferee can only exercise the option if the agreement to transfer between the transferor and the transferee subsists at the time when the option is exercised. A contract is valid till it is not reinstated or extinguished in any other manner. Once the transferee resigns the contract, this section has no application. Therefore, for the section to operate, both the requirements, namely that the agreement to transfer between the transferor and the transferee continues to be in force, and two, the transferee has exercised the option under that to acquire the property, must be fulfilled. However, both of these are contingent on and only operationalized where the transferor acquires subsequent interest in the property. In Agricultural Produce Marketing Committee versus Banama, the Supreme Court in 2014 clearly outlined that in a case where the transferor never acquired by succession, inheritance, or any other way any interest in the property during his lifetime, then the provisions of Section 43 has no operation. Another requirement that we need to focus on is the idea of good faith. This section protects subsequent transfers to third person provided certain crucial conditions are fulfilled. In other words, a transferee will be forbidden to enforce his claim against a person who has taken a subsequent transfer from the transferor in good faith for consideration and without notice of the option vested in the transferee. This means that if a third person takes the property in good faith after paying due consideration and without notice of the option with the original transferee, before such option is exercised, then such third person will not be affected by the original transferees under Section 43. For instance, if Vikas on partition receives property X and the other property Y goes to his father Sunil, Vikas, representing that he owed both properties X and Y, sold them to Chintan. Afterwards, when Sunil dies, Vikas inherited both the properties. But before Chintan could exercise his option to compel Vikas to transfer property Y to him, Vikas secretly sold that property to Dinesh. Dinesh purchased the property in good faith for consideration without having any notice of option of Chintan. Dinesh is entitled to get the property Y as against the claim of Chintan. If, however, the option had been exercised and the property is subsequently transferred to a third party, then such transfer would be invalid. Another key requirement for the operation of this particular provision is that the transfer itself must be valid. In the event the original transfer itself is illegal or invalid in law, then Section 43 has no operation, since expecting it to operate would be attempting to legalize something which originally to begin with was illegal. A transfer which was void ab initio cannot be made valid simply through the application of Section 43 of the Transfer of Property Act. The Supreme Court of India in N.S. Rao versus Special Court under AP Land Grabbing Prohibition Act, a 2006 decision, observed that when the initial transfer itself was invalid, the question of application of Section 43 to such a transaction on account of subsequent acquisition of title would not be available. In similar line, let's also look at the interface between Section 6A versus Section 43 of the Transfer of Property Act. Section 6A provides that while property of any kind may be transferred, the chance of an heir apparent succeeding to an estate cannot be transferred. That is, it is not a transferable right. Such transfer would be void ab initio. Section 43 of the Transfer of Property Act, on the other hand, validates the transfer made to transferee without title when the title is subsequently acquired by the transferor. In instances where the proposed transfer is spec successionist, that is, potential right to inherit, the question arises whether transferee will be entitled to seek protection of Section 43. Now, in the case of Juma Masjid versus K. Devaiya, a 1962 case, the Supreme Court observed that Sections 6A and 43 of the Transfer of Property Act relate to two different subjects, and there was no necessary conflict between them. The court observed that Section 6A dealt with certain kinds of interest in property and prohibited a transfer simpliciter of those interests. On the other hand, Section 43 of the Transfer of Property Act dealt with representation as to the title made by a transferor who had no title at the time of transfer, and provides that the transfer shall fasten itself on the title which the transferor subsequently acquires. Section 6A enacts a rule of substantive law, while Section 43 of the Transfer of Property Act enacts a rule of estoppel, which was one of evidence. The two provisions operated on different fields, under different conditions, and there was no conflict between them or for outing down the ambit of one by reference to the other. In the opinion of the court, both of the section could be given full effect on their own terms in their respective spheres. To hold that transfers by person who have only a spec succession at the date of transfer was not within the protection afforded by Section 43 of the Transfer of Property Act would destroy its utility to a large extent. Section 43 dealt with transfer which failed for the want of title in the transferor and not for the capacity in him at the time of transfer. For instance, a Hindu who has separated from his father B sells to C three lands X, Y, and Z, representing that A is authorized to transfer the same. Of these fields, Z does not belong to A, it having been retained by B in partition. But on B's dying, A as heir obtains Z. C, not having rescinded the contract of sale, may require A to deliver Z to him. As we conclude today's lecture, please remember that Section 43 of the Transfer of Property Act represents a very delicate balance between protecting genuine transferees and maintaining the integrity of property transactions. This provision, rooted in principles of equity and estoppel, ensures that those who make representation about property ownership must honor them when they eventually acquire the ability to do so. In your future legal practice, you'll find this principle particularly relevant when dealing with property disputes and transfers. Remember, the key takeaway, the importance of fraudulent or erroneous representation, the requirement of consideration, the role of subsequent acquisition, and the protection of good faith transferees. These elements work together to create a comprehensive framework for handling unauthorized property transfers. Thank you for your attention. In our next section, we'll explore more topics related to law of property. Please review the cases we discussed today, particularly the Juma Masjid and the Tanuram Bohras case, as they provide excellent practical application of the discussed principles. Thank you.